Let's just dive right into this explainer, shall we? Today we're looking at something that is literally the bedrock of civil lawsuits in South Africa. Now think about this for a second. You would never, and I mean absolutely never, hire a builder, point to a completely empty lot, and just say, hey, build me a house, right? No way. You'd give them detailed blueprints, exact material specs, the whole shebang. Well, surprisingly enough, the law works exactly the same way. We're going to explore this really vital, highly structured legal process called Instructions to Counsel on Pleadings. It's basically the ultimate architectural blueprint for a lawsuit.
So here's our quick roadmap for today. We'll kick things off with the legal project brief, then move into the split bar system, define exactly what pleadings are, break down the anatomy of the instructions, and finally look at why accuracy matters. Basically, we're going from meeting the key players all the way to seeing the very high-stakes consequences of getting this process wrong.
Okay, part 1, the legal project brief. Let's set the stage here. Here's the deal. Attorneys don't just pick up the phone, call an advocate, and give them some vague, hand-wavy idea of what a client wants. That doesn't happen. When an attorney needs an advocate to actually draft legal documents for a court case, they absolutely must send over a highly formal package of information and directions. In South African legal practice, this package is officially called the Instructions to Counsel on Pleadings. Remember our builder metaphor? Just like an architect needs tight specifications before drawing up blueprints, an advocate needs these crystal-clear, formal instructions before they even type a single word of a court paper.
Moving right along to part 2, the split bar system, and figuring out exactly who is involved.
Now this is really fascinating because it illustrates a strict dividing line in South Africa's traditional legal practice. On one side, you have the attorney. They're your primary lawyer, they deal directly with you, the public and the client, they gather up all the evidence, and they manage the day-to-day running of the case. Think of them as your project manager. On the other side, we have the counsel, which you probably know as an advocate. They're the true specialists in court litigation and complex legal drafting. You don't hire them directly. Your attorney hires them to argue in court and build that heavy-duty legal architecture. So attorney manages the client, counsel builds the case. Make sense?
Right, let's hit part 3. What on earth are pleadings? Because they are the absolute foundation of the case.
Okay, so what exactly is counsel being hired to build? Pleadings. These are the formal written statements that the two sides exchange right at the very start of a civil lawsuit. We're talking about things like a summons, the particulars of claim, or a defendant's plea. Their one major job, to clearly state the facts of the dispute. They make absolutely sure that both sides, and crucially, the judge, know exactly what the fight is actually about. Honestly, without pleadings, court would just be total chaos.
Okay, on to part 4, anatomy of the instructions. We're going to look at the 4 key components here.
This is the true core of our explainer right here. When an attorney sends that big brief over to counsel to draft those pleadings, the document follows a very precise, logical, 4-part structure to make sure absolutely nothing slips through the cracks. You've got the backstory, the legal framework, the paper trail, and finally, the mandate. Let's actually unpack each of these, starting with the backstory.
Okay, the backstory. This is where the attorney just tells the story of what happened in plain, simple language. Take this little micro-story for example. Our client, Company A, delivered 500 bricks to Company B. Company B accepted the bricks, but is now refusing to pay the invoice of 100,000 Rand, claiming the bricks were damp. Boom. It's simple, it's direct, it gives the advocate the exact historical context. In this case, a totally ruined business deal over some damp bricks.
Now, right after that factual backstory, the attorney has to explicitly lay out the legal framework. In law, this is called the cause of action. Basically, the attorney is outlining the legal basis for the claim so the advocate isn't just left guessing. They'll state, hey, this case is based specifically on a breach of contract, or it's a motor vehicle accident claim, or a workplace injury. It gives counsel the exact legal boundaries they need to operate within when they start drafting.
Next up is the paper trail. In the legal world, these are often called annexures or supporting documents. This is where the attorney attaches all the hard physical evidence they've managed to collect so far. We're talking relevant contracts, the actual unpaid invoices, demand letters, maybe expert reports like a doctor's note or an engineer's assessment of those damp bricks we mentioned earlier, and of course witness statements. The advocate literally needs all of this sitting right in front of them to review. And finally, to wrap the whole package up, we have the mandate. Think of this as the ask. The instructions absolutely must end with a specific, highly targeted request telling the advocate exactly what to do. Something like, counsel is requested to draft the particulars of claim to recover the outstanding balance of 100,000 Rand plus interest and costs. See?
Zero ambiguity. It tells them exactly what document to draft and exactly what outcome to chase.
Which brings us to our final section, Part 5, Why Accuracy Matters. And spoiler alert, the stakes are incredibly high.
Here is why all of this is such a massive deal. Advocates rely entirely, 100%, on the information given to them by the attorney in that brief. If they don't have a piece of info, they can't magically include it. And under South African law, you cannot just casually change your pleadings later in the game. If you suddenly realize halfway through the lawsuit, oops, we made a mistake in the drafting, well, correcting it requires a formal court application. And let me tell you, that is both incredibly expensive and hugely time-consuming for the client. So, the huge takeaway here is that the quality of the advocate's work is directly mathematically tied to the quality of the attorney's instructions. If the attorney leaves out one key fact, or, yikes, forgets to attach the correct contract, the advocate's pleadings are basically poisoned from day one. Flawed instructions equal flawed pleadings, and that will seriously, fundamentally jeopardize your chances of actually winning the case. It really puts into perspective just how vital this behind-the-scenes communication is, doesn't it? It leaves you wondering, could a single missing document or just one overlooked detail in those initial instructions truly cost you your entire lawsuit? Well, the stark reality is, yes, absolutely it can. And that is exactly why having a bulletproof project brief, perfectly structured and meticulously detailed instructions to counsel is literally the only way to ensure your legal architecture survives the intense pressure of the courtroom.